You're listening to Best Practices with Kenny Berger. On this podcast, we talk with the country's top trial lawyers about their approaches to every aspect of practice, from case selection to closing argument. Our guest today is Arizona trial lawyer Brian Snyder. Brian has been on the podcast before, and we're very privileged to have him back again today. Brian, welcome.
Thank you very much for having me back. I appreciate it.
Yeah. And Brian does a lot of medical malpractice and other catastrophic injury and wrongful death cases. And he's going to be talking with us today about opening statement. And Brian, with that, I'll kind of let you take the form. We can start big picture wise on opening and go through some examples and some specifics and just have a good time.
Yeah, I mean, I think we all spend a lot of time on our openings, but I personally think that you can win or lose your case in the opening. You still have to prove it the rest of the trial and make sure you don't give it away if you start out ahead. But I think that unfortunately, a lot of trial lawyers don't put as much emphasis on the opening as they should. They spend a lot of time on it, but they don't craft it the right way. And I just think that's a big mistake. We get to go first, and we get to set the stage for the story we want to tell. And so I spend a lot of time on my openings, focus grouping them to make sure I'm getting the story exactly right to be the most persuasive so we can start off the trial on a good foot.
And Brian, when you talk about putting a lot of time in, but maybe not the right emphasis, tell us more about that.
I think a lot of lawyers, we all like to hear ourselves talk, for better or worse. For me, it's worse. But I think we just go out there and want to just tell every single fact so we can make sure we cover everything. And we don't spend as much time as we should really honing it in, making sure we're sequencing it correctly, making sure we're telling the really important parts. If your opening statement is over an hour and a half, what are they going to remember from that? And so you need to be considering that, especially if it's going to be a 4, 5, 6 week trial. So really focusing on the key points, obviously, but telling the story in a way that is persuasive and that you can influence the jury, make sure they remember your key points. And I think what a lot of lawyers have a tendency to do is just start at the beginning and tell the story all the way through and end at the end. And that's not really the most persuasive or memorable way to do it.
And so when you're deciding, and we'll talk about sequencing, but when you're deciding what to put in the opening and what to take out, what's your thought process?
I start out with everything. I put in every single thing that I feel needs to be in there, and then I write it as a narrative, and then I move things around. So I start out actually constructing the story and essentially beginning to end, and then I sequence it in the best way. But my fear is always I'm going to forget something. So I write it all out, and then I go through and pare it down, eliminate things, add other things, and kind of handle it that way.
Yeah. And so when you're deciding what to keep and what to take out, are there any guideposts, any things principally that you found to guide you there?
To do that, I essentially use the sequencing component of it. So I start every opening with capturing their attention with some sort of important, significant statement or little vignette of what happened, and then go into where I want to focus on to begin with. And as we all know from all the CLEs we've attended over the last few decades, that we don't want to start focusing on our client because then the jury's looking at the wrong thing to begin with. So starting out with the defense meaning the defendant, or kind of the origin story of the case, which is not our client. It's not the patient in the hospital or the trucking crash or whatever liability there was. It's always something before that. And so that's where we start out at. But then I go through and hit the story. I hit the liability. I hit the causation. I do all the defenses, all the things they're going to hear to withdraw the sting, and then the damages. So I make sure I have those key headings, and then I just list every important fact or argument that I can think of, and then I go through and just kind of wean it down step by step to really get to the essence of what's the most important.
Yeah, and so as you're doing that, what are your thoughts in terms of visual aids, demonstratives, Keynote, PowerPoint, the blend of when you want jurors looking at the visual and when you may want them looking at you or the defense table or otherwise?
Yeah, well, I mean, anyone who's seen me knows I don't want anyone looking at me the whole time. That's for sure. So I want them focusing on the facts. And we all know just saying it, they're not going to remember things. In Arizona, jurors are given notebooks to write things down. And I encourage them at the very beginning of my opening statement to take notes. And I do it in a way that um, is kind of rooted in that it's in their best interest because it holds us accountable. I tell them, you're allowed to take notes, you're allowed to ask questions during trial. And so please do take notes. Write down what I say in my opening and the defense, and then see which one of us proves what we said we're going to prove. Because we all know that the defense attorneys will get up there and make these outlandish promises that they can't keep. And so I want them to know that I am sticking to the facts. So I encourage them to take notes. Um, but in terms of visuals, I think visuals are critical. If you are the most eloquent speaker of all time and you just have this presence about you that can captivate people, maybe you don't need visuals, but that's not me. And I know that's not me. So I use a PowerPoint or a Keynote in every single opening. Um, but they are not busy slides. You will never see a slide that has all text on it, ever. Most of them are either just graphics or graphics with some key facts or points in it. And the first time I was lucky enough to be invited onto this podcast, I talked about using images and kind of icons to make your message persuasive, and I'd still do that in my openings. It's key graphics that can trigger their memories later on that, oh, Brian told me this before. I remember it from his opening, and now he's proving it here at this cross-examination or whenever it is. So I think graphics are extremely important, but you can't overdo them, just like everything else. You don't want to stand up there for 2 hours just talking, but you also can't show 500 slides of all different graphics because then everything just gets lost in the noise.
Yeah, and for folks who haven't listened to it or don't recall it in its entirety, or the conceptually, I should say, the first time Brian was on, we talked about the jurors are only going to remember so much of what happened during trial, and to get their attention focused on the things that you want them remembering, that you want them deliberating about. Really, if you're having to pare down your case to say the 5 or 10% of what jurors truly recall once they go into that deliberations room, that 5 or 10% are the things you really want them to recall about your case
Right.
and the strengths of it. And and the way that Brian and I first met was I actually saw him do a 15-minute presentation on that concept or that approach. And I was like, man, this guy's brilliant. We gotta have him on the podcast, and I gotta get to know this guy. And we've become good friends over the years, thankfully. And what I'm hearing you talk about in your approach to opening is very similar.
Yeah, absolutely. And it permeates throughout the whole trial. But the opening is the first time that you really get to show the jury anything. I mean, yeah, you're talking to them in jury selection, but they're not showing them anything. And so this is the first time you can actually start showing them important information. And every judge, every state is going to have different rules on what you can and can't show. So I stick to the most benign, simple facts that I know I can prove, I know I'm allowed to show, that aren't going to raise any objections, to try to educate the jury through the use of not only the facts, but also these kind of corollary graphics that will spur their memory later on. So I'll show you in a little bit. If there's a hospital policy, I am showing that policy right away. That's the whole crux of the case. So the jury's going to see the policy. So they know I'm not making it up. I'm telling them exactly what the policy says. And look, here's the document that shows it. And then in anyone who's tried hospital cases knows that the defense the hospital always uses is, oh, that's a guideline. That's not a policy. That's They're allowed to use their judgment on whether they follow those guidelines, which is nonsense, but that's what they try to do. But the testimony is always you have to follow the policies. Every nurse, every doctor is going to say you have to follow policies. So the graphic I'll show you is a stop sign. It's always a stop sign because everyone knows what that means, and you attach it to the policy. But yeah, I think showing graphics that support your story in the case is critical, especially to explain difficult concepts. And that's probably the best place to start here is we know our cases inside out. At least I hope we do by the time we get to trial. And the jurors have no clue. They come in with nothing. And so when you're trying to explain a really difficult concept, you have to use some sort of a graphic to break it down so they can easily digest each part of it. And then you can build on that going forward.
Yeah, and Brian, before we get into some of the examples, where are you in terms of making sure you've addressed the pieces that you want to make sure you hit on, while not leaving yourself perhaps vulnerable to points the defense is going to bring up that are salient, that may resonate or may land? I mean, there's some things that are just outlandish that's like, I may not bring this up in an opening because I don't want to give it any credibility or credence. But the points the defense may have, they're like, that is something that we're going to have to deal with. If you're wanting to show a lot of discretion and discernment in what stays in and what goes out, where do you strike that balance in terms of dealing with the defenses?
So first place I'm doing that is in jury selection. I don't want them hearing about it for the first time in the opening statement. I want to address it even before that, just so we can get feelers out. Hey, what do you all think about this? And I mean, I think the Jerry Spence method, the trial lawyers college, and kind of what everyone has adopted over the years is you make it personal. Something that I've struggled with in this case is that the defense is raising this issue, and our experts will talk about it, but it's something that worries me because I don't know how it's going to come out necessarily here. And so you kind of address it in voir dire. But then in opening statement, I have a whole section of just defenses. And it's at the end. I'm not leading with that for sure, but I also don't want it in the middle of my story. I want to tell my whole story from beginning to end, other than damages, and get it out there as clearly and persuasively as possible. And then after they've heard those facts, hopefully stated very succinctly, then I bring up their defenses and say, well, you've heard what happened here, and now this is what they're saying in response to that. And I try to make the slides as argumentative as I can without crossing the line to show how absurd they are. Despite all the evidence, despite all the literature, despite all the admissions, defense still believes X. And then I address each one by one. I absolutely do not want them hearing it from the defense counsel for the first time. That to me is catastrophic, because if I don't get to address it first, then they're going to put their own spin on it, and who knows who's going to latch onto it. So I address those, and then after that I end with damages, because I want them feeling the emotion at the end of my opening. When the defense comes up and starts to spew all their nonsense, I want them still in the emotional part of it. And so I cram the defenses in there between causation and damages.
Got it. Now, curiosity on a med mal case where, y'all aren't trying to med mal case if the damages aren't very, very large, some type of severe permanent harm, or death. When you were talking about sequencing, I remember years ago, med mal attorney was talking about sometimes they'll, instead of talking about, in essence, duty and the violations or breach of those duties and the injury it caused, they'd more lead with this terrible thing that happened that obviously isn't supposed to happen when you go to the hospital. And then they talk about how it happened, and then they talk about why it should have never happened. Are there times where you play around with sequencing what I would just call the elements of the tort?
Yeah, absolutely, but not to the fullest extent. So I will never discuss all the damages up front. I want them to see and hear what happened, so they get this kind of impending sense of doom about what's going to happen here, they can fill in the gaps themselves. They know when they hear about the policy, then it's, oh my God, they must have violated this policy. Why else is he showing this to us? And then go through it that way and then get to the damages. But to your question, absolutely. We put that little vignette at the beginning, that little story, that can absolutely be damages. It can be a moment in time of if it's a death case, the person lying on the hospital bed coding, how did we get here? And make it an emotional kind of capture. But yeah, I think one of the things I've always struggled with is when and we all do it, we hear someone speak at a conference, we read a book, we say, oh, I'm going to do that. It doesn't work like that. Every case is different. They're like snowflakes, right? So you can't just take an approach that someone else has done and had success with and say, I'm going to do that and I'll win, because that's just not the way it is.
It's
So
like
if
if
your
you
case, oh, sorry, go on.
it'd be like if you heard like, when you were coming up, like the cool older dudes, like, oh man, you walk up to her, you buy her a drink, you did it, whatever it is, right? And it'd be like if like you were at I don't know, you met somebody at church or synagogue, you're like, hey, I want to get you a drink. It's like, what are you there are no drinks here. What are you talking about? It just
Yeah, you need to know your
yeah.
situation, but it's like the movie Anchorman when he says 90% of the time it works every time. Well, I mean, it's kind of the same thing. Yeah, it might work. There are brilliant trial lawyers who we would all be nuts to ignore what they've done to have their successes, but you can't just say, I'm going to use this method and it will result in a victory for me, because it just doesn't work that way. If it did, no one would ever lose a trial. So I always think it's important to learn from as many people as possible, as many different methods as possible, and borrow from each of them to make it fit you. I am a firm believer that if you are not authentic in front of the jury, they're going to pour you out. If they see through you, if they think you're not just lying to them about the facts, but just faking the emotion, faking the kind of the righteous indignation, all that, they're never going to find for you. And so you have to find what works for you. I just did a trial lawyers college workshop this last week, Jerry Spence method. And I used to always think all that emotional stuff, that's just not me. And then I did it. And now I absolutely believe it's me. I could get up there with complete sincerity and talk from my heart and my gut in an emotional way and tell the story that people could then remember because it was so emotional. 2 weeks ago, I just said, I can't do that. So I think it's important. You test things out, see what works, see what doesn't work.
Speaking of testing out and seeing what works and what doesn't work, what do you like to do generally as far as order of proof in terms of first witness after the defense gets done, or first and second witness after the defense gets done?
I always have someone, whether it's my nurse expert or a physician expert, who can tell the whole story from beginning to end. That person may not be able to give opinions on the whole thing because of his or her specific specialty, but someone who can just tell the story. I don't want the jurors having to piece together parts of the story here and there and hoping they get it all. So most of the time it's going to be a nurse, because nurses are involved along the whole way. They see the other specialists come in and leave. They know about the imaging. So in my last trial, birth injury case, the labor and delivery nurse told the whole story. And she was a great witness and did a great job at it. But that's the other thing. If you have someone who can do it, but he or she's just not the most exciting person to hear, you don't really want to start off that way. But I never have the client go first if I can help it. I always want to save that for the end. If the client's a good witness, save them for the end and end on the high note with that.
Yeah. All right. You want to get into some examples of your opening from this most recent trial?
Sure. So the last time I was on this podcast, I talked about this birth injury trial. So I won't go into the details of it, but just kind of the nutshell is
This is the case you and Gary Dordick tried together.
Gary Dordick and I tried it along with his associate, Chris Ballone. So Gary did voir dire, I did the opening statement, Gary did closing, and then we split up the witnesses in between. So
and along the way, y'all got a record-breaking verdict.
Record-breaking verdict in Arizona is the largest med mal verdict in the history of our state. And it was a really proud moment. Yeah, it's great to have a huge verdict, of course, but to help out a child, one of the things I really do have a difficulty with a lot is that wrongful death cases are really important, but the money can't help. It doesn't do anything to actually fill the void. This case actually could help this young boy get treatment for the rest of his life. It could take all the pressure off his mom, and the jury responded and they did just that. So it was a really, it was sad that we had to be there, but it was a really happy moment, personally and professionally. So just kind of the nutshell here is that our claim was that the hospital ignored fetal distress on the fetal heart tracings. There were a lot of decelerations when the baby's heart rate drops, and they weren't responding appropriately. They kept the Pitocin going when the hospital policy required it to be turned off. And
tell us, what is Pitocin supposed to do?
So Pitocin helps with the contractions to progress the labor, but the problem is it's actually a very dangerous drug. There's a label warning on it for its dangers. It's not, even though it gets used in a significantly high number of pregnancies, it's still very dangerous. And so there are times you have to stop it. And it's just an IV, so they can turn it on, turn it off. And the hospital had a policy about that, which was ignored by the nurses and the doctor. So the baby ended up having what's called a hypoxic ischemic brain injury, lack of blood flow and oxygen to the brain, and has cerebral palsy. So when we were kind of putting the story together, the very beginning, I wanted to set up what should be the emotion going into labor and delivery, the excitement, the just pure happiness. I'm going to have my baby. This was the mom's first baby. And so that's where I started, talking about the happiness and the excitement when you find out you're pregnant, when the months progress, and then you start having contractions and you're in labor and you're so happy and excited. But so that's where it started. And then the end of that little mini opening, as I kind of call it, was the baby being born blue, limp, barely any heart rate, not breathing. Because now you know something went wrong. And now it's, well, what went wrong? What caused it? So I'll share my screen here with you. What we did was we divided the story into 3 stages. It was the danger, the damage, and the denial. And I know it can be hard to see, but in the background there is a picture of Grayson, the baby, when he was born in the NICU. He's in the NICU at this point getting treated. But so the jury now knows, well, there was some sort of danger. We know there was damage. And then, well, what's denial? That doesn't really make a lot of sense. Well, in this case, they lost the fetal heart tracings. They denied that all the diagnoses from their own doctors in the hospital and the NICU, the radiologist, they denied that all that was accurate. They all diagnosed HIE, and the defendant Banner was now saying, no, he doesn't have HIE. So they were denying what their own physicians and nurses and nurse practitioners all said. So now they know, all right, we got 3 stages here, and now we fill in the blanks. And I go one by one with the danger, starting with Pitocin. And I'll just show you real fast here, and then I'll stop for a second. But the policy on Pitocin, so maybe kind of hard to see on here, but this is the hospital's actual policy on Pitocin. And then this other, it's a PowerPoint slide from the hospital where they trained the nurses on this policy. So we have the policy in writing, and then we have the training that they expected the nurses to follow it, and this is how they train them. And this was the slide that distills everything. When the baby shows any signs of
Brian,
reduced.
for the folks who are just listening and not viewing, will you describe
Oh.
the slide for us?
Yeah. So at the top here, it says Banner has a rule that when a baby shows signs of reduced oxygen and blood flow, stop Pitocin. And then I have a fetal heart tracing, a little snippet of one with an arrow that says oxygen blood flow. So decreased oxygen blood flow, and then a bag of Pitocin with the stop sign on it. Decreased blood flow, stop Pitocin. Very simple. And that's literally what the policy says. I'm not making it up. It talks about category 2, which I'll show you in a second, because that was one of the things I was saying before, that when it's complicated, you have to break it down for them. But this is a very simple slide. This is what the nurses are taught, this is what they're expected to know, and now the jurors can understand it very simply. I also think it's important to show the bag of Pitocin, because the moms on the jury have probably seen Pitocin before, but the men probably haven't. And if you haven't had a baby, you probably haven't. And so it's important that they know it just looks like a bag of IV fluid, because that's all it is. So I want to show you this part. When I was mentioning before the complicated concepts, and I'll just mention what I really don't believe in AI for a lot of stuff that we do as lawyers. I just don't think it's even close to there yet. But one of the things it's really good at is I put in a concept and say, explain this to a 6th grader. And then I still have to tweak it and clean it up a little bit, but it explains these really complicated concepts that I can then use to a jury who has no prior knowledge of any of this. So,
and Brian, which AI tool do you like to use to do that?
For that, I just use ChatGPT. It does a pretty darn good job of it. And I haven't had one yet where I haven't had to just tweak it a little bit, because it always goes a little over the top on, well, kids, let's sit down and learn about category 2 tracings. But the nuggets are there, and it saves me a ton of time trying to figure out how can I distill this down. So in fetal heart tracings back in about 2010, they came up with categories. Category 1 is everything's totally normal and fine. Category 3 is we got to deliver this baby right away. There's a impending emergency here. And then category 2 is this nebulous catch-all of everything that's not 1 or 3. And it's a complicated classification system, so much so that nurses don't even agree on what's category 2 or not. And category 2 sometimes can be really bad and sometimes may not be bad at all. So I created a slide, and I'll explain what it's looking at, or what you're looking at here. But the 3 categories, I just put them out there, and I have them show up one at a time. I don't ever want the jurors looking ahead if I'm not talking about it yet. So the first one says category 1, and it's in green writing, because green means go. Everything's normal. Baby's happy and healthy. No problems. Green, happiness. Then next one that shows up is the category 3, because that's dangerously abnormal and very rare. And category 3 is in red type. Red means stop. So category 1 and 3 are pretty easy to explain. But then I go into category 2, which is where this baby was almost the entire labor and delivery. And it says on the slide, it's in orange, slow down, caution. Hey, you need to pay attention here. But it says can be evidence baby is not getting enough oxygen. And so the nurses, the doctors need to be aware when you're in category 2 that things may be okay, but they may not be okay. And the reason this slide is so important is because, and the very next slide is, category 2 can be evidence that the baby is not getting enough oxygen. And what the policy says is for category 2, the nurses have to stop the Pitocin. So there's a stop sign there with the policy attached together. So now they hear category 2, they see the banner policy, and they see the stop sign, and it's all on one slide with, let's see, 10 total words on the slide that I typed, and then but the graphics. And it just is a simplistic way for them to remember category 2, stop Pitocin.
And Brian, what would be the markers that the baby's not getting enough oxygen? What would be the criterion for being in category 2 and therefore stopping Pitocin?
So I have a slide for that. Category 2, It's an orange because I wanted being consistent. It was an orange before, it's an orange now. Still with the stop sign in the policy. And there are different things. One is variable decelerations. And so I have that on here and explain what it is. A drop in the baby's heart rate. It usually means the umbilical cord's compressed, but it's a sign that oxygen and blood flow are being cut off. And so variable 2 decels make it a category 2 tracing. And then I created this slide, which is really busy. I didn't really like it at first, but when we focus grouped it, they really did like it. And what it is for those who can't see it is all the different times from the chart that this baby had variable decelerations from the beginning to the end. Almost every labor is going to have a couple, but he had a ton of them. And it tells you the time, and then they all stack up. And so you see this slide that shows he had 23 separate variable decelerations. And there's if you can see it there, a red flag in the corner, because that's a big red flag. Babies in category 2 may not be getting enough oxygen. So
And
that's
Brian,
one.
again, with all these, with the red flag, with all the variable decelerations, with what appears to be, I just call it clear and convincing evidence that you'd be in category 2 and therefore stop the Pitocin. I mean, one of the things that's standing out to me is this looks to be, and correct me if I'm wrong, it looks like this was transpiring, these variable decelerations, to let you know that the umbilical cord was being compressed. I mean, this is going on over a long period of time.
Yep, the very first one's at 9:45 a.m. And like I said, every mom's going to have it at some point. So 1 or 2 is not such a big deal, but at 9:45 a.m. And then the last one was right before birth at 1:30 a.m. the next day. So over, I think it's 19 hours, somewhere in that range, 18 hours, there were 23 separate variable decelerations. And I have them appear, I don't go over each one in the opening. That's overkill. No need to go over each one. They see it. I explain what it is, explain why it's important. And then this slide, it animates and it shows each one. Each one appears one at a time, but it's quickly. It goes pretty fast. And then they see them all and they're in red. So it's a big deal. But yeah, it was happening throughout the entire labor, which is why it was so important that they delivered sooner.
And Brian, one of the things I'm seeing too is that early on, during the labor and delivery, maybe these decelerations are further apart in time or less frequent. But then once you get to about 10 o'clock or 9 o'clock at night, you know, it seems to me every time they're checking or every half hour, you're having these variable decelerations. At that point, are they still giving Pitocin? I mean, for me, that's like, man, maybe if you have 1 or 2 during labor and delivery, okay, you know, maybe it's a longer delivery, maybe you have a little bit more, but once I'm seeing them like over and over and over and over again, you know, for me, just as the juror who doesn't know much about the case, I'm starting to wonder, like, are they still violating their policy and giving them Pitocin this far into the labor and delivery?
Yep, and that's the whole point. That's why the sequencing is so important. Because if I hadn't told them about the policy yet, then this means nothing. They know already that the policy from the hospital is you have to stop Pitocin anytime you're in category 2. Doesn't matter if it's for a minute or an hour, you have to stop it. And now there are 23 separate times. So far, you'll see more, but 23 times babies in category 2, and they don't stop it at all. And so it gives you this feeling that this outcome was inevitable because of what they're doing. They're just ignoring these red flags.
And so, you know, one of the things I'm wondering, again, if I'm a juror and I'm looking at parts of the opening, is the reason that they would be ignoring this. I'm thinking, you know, there's got to be a defense, and the defense is either no, these variable decelerations in category 2, that's not real, or, you know, there was some compelling reason to provide Pitocin, or the Pitocin, you know, and what was going on was an approximate cause of what happened to this poor child, that maybe something was already wrong with the child before the labor and delivery began?
Yeah, in birth injury cases, they throw the kitchen sink at you. They don't care if it complicates their own defenses. They just throw everything at you. So they put in, oh, this injury already occurred, even though the tracings were totally normal at one point. But they also lost the tracings. And so we were relying on what was in the records, which may or may not even be accurate. There could have been more variable decels. We don't know. This is all that we have access to. But one that again with the sequencing, one of the reasons that that I sequence it this way is to build on each other. So before I get into this slide you're looking at is a transition slide, and it says the records show extensive evidence of fetal distress and lack of oxygen. And I'm going to show you all the different ways that the nurses and doctors knew that there was a potential issue here. And the first one is the variable decels that we just went over. And then I go back to policy, stop sign. This is evidence of distress. And then the next one are these prolonged decelerations. So it's exactly the same slide as the variables, but now we're talking about prolonged decelerations that are a drop in the heart rate of 2 minutes or more. And again, it shows oxygen blood flow is cut off. And the stop sign with the policy is sitting right there next to it because this is another way you can be in category 2. So the prior slide was 23 variables, and now we have 6 prolonged decelerations. So it's the same slide, but now we're adding on to it with the prolongs. And look at this, at 10:15 a.m., 2 minutes long. That is 2 minutes of time where the baby is potentially not getting enough blood and oxygen to the brain. An hour and a half later, 3.5 minutes. That's a significant amount. At 5:45, 5-minute deceleration. That's 5 minutes where baby is getting compromised blood flow. And then right at birth, at 1:45 a.m., there's another 2.5-minute prolonged decel, which is significant. And then at the bottom of the slide, it mentions 2 other ones that the nurse somehow forgot to document in the chart, but the resident doctor said, oh, there were these 2 other ones, and they don't match the times or the lengths in the chart. So we know there were 6. So this is another red flag of when they should have been stopping Pitocin. And prolonged decelerations are really important. They're bad. And again, you may have 1 or 2, but 4 to 6, never okay. So
Brian, stands out for me. I mean, if at 5:45 this child has a 5-minute prolonged deceleration, what is standard of care?
deliver that baby. Mom was at term. There was no reason not to deliver. You get the C-section done. That's what it comes down to. Get it ordered, get her consented to it, and get it done. Why take the chance? There's no reason to. And sure enough, what happens afterwards, you get another long one right before birth that was the kind of the final knockout punch. So
yeah, and I know we're talking about opening, but also think in going over your opening, the points we're discussing, the questions I'm asking are evidence of why this was such an effective opening presentation. So what was the hospital's explanation or defense for why they didn't deliver at 5:45 when you've got a 5-minute prolonged deceleration?
there's no reason to. No actual evidence baby was in distress. There are other findings that you read on the tracings. Accelerations, does the baby's heart rate come back up quickly? Is there variability with the beat to beat from the heartbeat? So is there movement, or is it just kind of flatlined? And they said, hey, there was variability, there were accelerations. Those are both signs that everything's okay. And that's true. That is evidence that the baby could be okay. But they wanted the jury to say, well, don't worry about the evidence that baby's not okay. Let's focus on the other stuff. And the problem was we had a PowerPoint presentation from them where they teach the nurses that says moderate variability and accelerations do not mean that the baby's okay. It's just evidence of that they might be. It's a suggestion. So
And I don't get why it's like, all right, if the baby might be okay, but the baby might not be okay. It seems to me like erring on the side of caution would indicate that you go ahead and do the C-section and address the potential issue versus a catastrophic result.
Yeah, absolutely. At least talk to mom about it, give her the choice. But no matter what, you have to stop the Pitocin. You can't keep doing that because the more Pitocin you give, the more contractions there are, the longer they are, the more pressures on the baby. And every time mom contracts, blood flow is cut off to the baby for that time period. And so if you're giving more Pitocin, then it's going to cause more problems. That's why the policy is to turn it off, because you have to give baby a chance to recuperate and recover. So we
So
have
Brian,
prolonged.
what do you do? What do you do when it comes to, I guess, what I call almost like in a, you know, theater or poker term, like the turn? Like where in the presentation are we kind of going through, and then it's like the, you know, almost like this climactic moment or this turn where it's just the reveal.
So in this, I mean, they had it at the beginning. Again, I want them to know what the outcome is so they can fill in the gaps of why it happened with this evidence. But I mean, I remember standing there giving this opening statement, and this part, you try to make it dramatic, you try to make it interesting, but look, there can be some dry moments there. You're talking about factual things. But when you talk about the baby being born and he's blue and limp, not breathing, barely has a heart rate, that's the moment of, oh shit, all those things that we just saw. And that little story at the beginning about when he was born, it all comes together now. And you can see it on people's faces in the jury of, oh my God, this is a defenseless baby. Baby did nothing wrong. And this is how he comes into the world because of all these choices that were made. So that was kind of I mean, the reveal, it wasn't a surprise because they already knew about it, but that was the emotional reveal, I guess.
Yeah, and I mean, I'm thinking about, you know, when our child was born, and what did what did the folks in labor and delivery do after Grayson was
I mean, well, it depends who you talk to. So they got the NICU team there to resuscitate, but they didn't call the NICU, even with all these red flags and warning signs. And there are some that I didn't even show you yet. Another type of deceleration that's really bad that there were several of, pressure on him that they knew about. They never called the NICU team to be there at the bedside. So when he's born, they say, we're so surprised about what happened. We had no clue this was going to be an issue. So they call the NICU team, they resuscitate. But one thing we didn't know going into trial, that so I would have put it in my opening, but I didn't know about it until the testimony at trial. One of the first things they did was notify risk management. So they knew, risk management knew about this birth shortly after birth. And that was a pretty compelling piece of evidence. Why are you telling, if this isn't such a big deal and it's just, oh my God, you know, shit happens. We didn't want this to happen, but no concern at all. Why are you telling risk management so quickly? So, but again, when you see all of the red flags, all of the stop signs building up, building up, building up, then it's like an indictment of themselves when you find out this new piece of information that they notified risk management.
Yeah, and I'm not sure what the law is in Arizona. In your openings, if you're allowed to, or if you're not allowed to, it answers the question. Are you talking to the jury either in voir dire and or opening about a specific dollar figure or about a range?
I don't. In voir dire, every judge out here is different. Some don't allow you to do it at all. Some say you can do whatever you want, and some say you can't give a dollar amount, but you can tell them it's going to be a big number, and that's what this judge did. So we told them we're going to be asking for, my recollection is we said millions and millions and millions of dollars, something like that. In opening, I don't mention a number. I don't think there's no rule for or against it, but I don't think most judges would let you do it. But what I do tell them is we're going to stand before you at the end of this case and ask you for what's fair and reasonable. But but they know. I mean, I put in the life care plan numbers in my opening. I put in we waived the past medical bills in this case. They were like 900,000. So that didn't come up, but the life care plan, and then just all the stuff that Grayson has to go through every day. So by the time I'm done, if they're on our side, they know that this is tens of millions.
How's Grayson doing now?
He's doing well. I mean, he's fighting hard for therapies and every day trying to go through it. And we just so Banner had appealed the verdict, and then the appeal went away, and with the probate court just finalized everything last week. But he's going to get the equipment that he needs. He's going to get a new walker that's really expensive that he needs to get around. And knowing that now these therapies and devices can be paid for, you don't need to rely on the state. And I mean, it's a really amazing thing for him. I mean, it's a horrible situation, but at least we can make the best of this really crappy hand that's been dealt to him.
How are his parents?
Mom's great. Dad's a good guy, but he's not really in the picture very much. They're separated, but mom is an amazing client, amazing person, but she works a full-time job and takes care of every single one of Grayson's needs. And it's really unbelievable. You know, I don't know what you were thinking when you guys were pregnant and then had the baby, but with my three kids, my mind always kind of goes to worst case, like what happens if, and you want to think that you're going to be that parent that, hey, my whole life is going to be dedicated to this. And yeah, I would hope it would be, but a lot of people get overwhelmed with that and can't do it. And she's a stalwart for sure.
Yeah, thank you for fighting the good fight. Did y'all have Grayson there for any portion of trial?
He was there for opening statement, and I introduced him to the jury at the very beginning, my opening. He has an iPad that he can speak, but it's very slow and drawn out, and it's hard to hear him. So he has an iPad that he can type into, and it speaks for him. So he really wanted to say something to the jury. So we let him obviously do that, but the iPad kind of malfunctioned. And so he didn't get his chance to do that. But what was funny and heartwarming and endearing was he's cognitively aware enough that he knows what's going on, but he doesn't really understand the significance of it all. So when I'm giving my opening statement, every time I mention his name, he starts laughing and smiling because he knows we're talking about him. And he is just the happiest kid. He always has this big smile on his face. And so we had this dichotomy of like a juxtaposition of happiness on his side and horrible sadness on my side and the juror side. But that hope that even in this horribly dark time, there can still be happiness is a huge motivating factor for jurors. They don't want to be depressed. They want to come out of this thinking they can help this boy. And when he's smiling and laughing and giggling every time he hears his name, it gives them hope that they can help him. So it was really nice having him there. And I mean, I can see why some people might think it's a sympathy ploy, but it's really not. This case was about him. His mom didn't have a claim. It was just him. And he should be there because it's his claim.
Amazing work, and I'm glad that he's going to have everything he needs from a medical standpoint and equipment standpoint for life. Brian, for folks who want to get in touch with you to discuss medical malpractice cases, be it in Arizona or anywhere in the country, including South Carolina, what would be the best way for them to do that?
Our website is snyderwenner.com. My email is Brian, Brian, at snyderwenner.com. And Wenner is Wenner. But happy to talk, happy just to bounce ideas off. We do litigate cases all over the country, but I think that the reason the plaintiff's bar has advanced so much over the last few decades is because we share information with each other. This is a fight that we all participate in. And so You don't need to bring me into a case to discuss it. I'm happy just to talk and kind of flesh out ideas. But the last thing I just want to mention is I am a firm believer that if you work up your case properly and you take the time, focus groups, laying it all out there, and then you show the proper emotion when you're in court, not contrived, not minimizing it, that you are just putting your true self out there, that good things happen. I mean, we all lose cases that we should have won. We all win cases that we probably should lose, but we need to do a better job as lawyers of really getting in touch with our emotions and showing the clients and the jurors what the real purpose is. And it's not to line our pockets. At least it shouldn't be that. And so I would really recommend that everyone just sit down and think about what emotions you want the jury to walk away with from your opening, and how you can communicate it to them. Because if you do that, you start out with such an advantage going into the witnesses, and things can always go wrong at trial, but if you can start out with a lead, then you increase your odds significantly.
This Brian Snyder, fresh off TLC Jerry Spence weekend, is I like this guy. I like this guy before. Man, this is good.
You know who likes this guy even more now? My wife. She said, wait, so you're more emotional now? That's fantastic. So, but I really do believe it. And as long as it's authentic, I really believe it.
Well said. Listen, everyone, thank you so much for joining us again. Our guest today has been Brian Snyder, medical malpractice lawyer, and again, an indispensable member of the bar nationally. And you have been listening to Best Practices with Kenny Berger. Thank you so much for being part of the podcast. Take care.